All right, we've been given the all clear and y'all are good to go.
All right. Um, Hello, good afternoon, I guess, for everybody. We received a message to get started, so let's call the case of Stevie Rogers versus Drew Mars to order. My name is Judge Sood. Scoring judges, please look to the two buttons on the lower left of your screen. Just remember to keep your audio and video off unless the bailiff chimes in and lets you know otherwise. You should also have your video set to hide all non-video participants at this point. This means the only people on the screen right now should be the advocates and me. Assuming everyone's all set with that, can we please have the attorneys state their appearances?
Yes, Your Honor. Good afternoon, Your Honor. My name is Pranav Gandham, along with my co-counsel, Ms. Katie Burdett.
Good afternoon, Your Honor.
We represent the plaintiff in today's case, Ms. Stevie Rogers.
Good afternoon, Your Honor.
And would Your Honor like to hear pretrial matters or hear introductions from the defense first?
Why don't we do appearances first, and then we'll handle all pretrial matters?
Yes, Your Honor.
Yes, Your Honor. Good afternoon, Your Honor. My name is Michael Young, and along with my co-counsel, Christopher Alexander,
Good afternoon, Your Honor.
we represent the defendant, Ms. Drew Mars.
Good afternoon, Your Honor.
Excellent. So there's some pretrial matters. Plaintiff, would you like to go first?
Yes, Your Honor, just a few. First and foremost, we'd like to invoke Rules 603 and 615, which respectively call for the pre-swearing and constructive sequestration of all witnesses besides party representatives. For this trial, our party representative is the plaintiff, Ms. Rogers.
Assuming the defense doesn't have a problem with that.
No, Your Honor, just like to recognize that our party representative is the defendant, Ms. Drew Mars.
Okay, no problem. That's granted.
Additionally, Your Honor, considering the unique nature of this trial, is it all right when authenticating evidence before we enter it to assume that it's in front of the witness so we don't put it up on the screen in front of the jury?
The defense, do you have a position on that?
No, Your Honor, we would just like to further ask for whether you want us to ask for permission from the court before displaying something on the screen.
So I think given kind of where we're at, why don't we do this? Until something, we'll assume that nothing is seen by the jury until it's been admitted into evidence, but understanding sort of the limitations technologically and all that, if something is displayed, we can assume that that's done outside the presence of the jury, and then only until it's admitted into evidence do we assume that the jury has had a chance to see it. Does that work for both of you and your party?
Yes, Your Honor.
Okay, why don't we handle it that way?
And finally, Your Honor, we would just like the court to take notice that in this case, exhibits 1 through 7 have been pre-admitted. We can reference them at any time.
Okay, defense, I assume you're aware of that.
That is our understanding as well, Your Honor.
Got it. Okay, perfect.
And with that, we're ready to go with opening statements.
All right, defense, do you have any pretrial matters?
Briefly, Your Honor, I just want to clarify whether you want us to ask for the court's permission before putting a document on the screen or do so.
I would say, why don't we do this? Unless there's going to be some sort of objection that's raised, why don't go ahead and ask for permission to display and just afford the other party an opportunity to object should there be something. I don't anticipate that there will be, but let's just give them the opportunity. And so that I guess that's the easiest thing to do.
Yes, Your Honor.
Okay.
With that, the defense is ready to proceed to opening statements.
Perfect. All right, we will now hear the opening statements from each party. Everyone should make sure they're in speaker view. That button is in the upper right-hand portion of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. And whenever you're ready, Mr. Gundam.
May it please the court. To stay in the will, she had to kill. It's August 15th, 2018. The defendant, Drew Mars, walks into the bedroom of Agatha Lee. For the past 10 years, the defendant has been working as Miss Lee's caretaker, and she's checking on her like she would any other morning. But you'll learn this wasn't just any morning. Because this morning, August 15th, Agatha, she wasn't moving. She wasn't breathing. She didn't have a pulse, but the defendant wasn't worried. She certainly wasn't surprised because she was the reason that Agatha was dead. You see, for the past 10 years, the defendant thought she was the sole beneficiary of Agatha's will. That when Agatha died, all of her assets would go to the defendant. Now, that was quite a lot. Agatha had made a fortune as a best-selling author. Her assets totaled upward of $25 million. All the defendant had to do was wait for her to die. She wouldn't have to worry about money ever again. But then the defendant on August 14th learned what you're going to learn today. That Agatha changed her mind. That Agatha called her granddaughter into her study and said, hey, this money's going to you. I'm not leaving anything for the defendant. The defendant realized that she had to act quickly. She realized that if she didn't, the millions she stood to inherit would be gone in an instant. She realized that to stay in the will, she had to kill. And the evidence will show exactly that. Because on the night of August 14th, the defendant walked into Agatha's room, switched her medication for a deadly poison, and the next morning, Agatha was dead. And everything she owned went straight to the defendant. To stay in the will, she had to kill. But unfortunately for the defendant, in Midlands we have a law called the Slayer Statute. It's not a law that you might have heard of, but it's a law that makes sense. And what it says is that if someone kills somebody else, they cannot inherit any part of that person's estate. In other words, if you kill someone, you cannot profit off of their death. And that's why Stevie Rogers, Agatha Lee's granddaughter and last living relative, is suing the defendant under the Slayer Statute. Now, we as the plaintiff, we bear the burden of proof in this case. In order for us to meet it, we need to show you one thing, that the defendant knowingly caused the death of Agatha Lee. We need to show you that by a preponderance of the evidence. In other words, that it's more likely than not. And we're going to. Because throughout today's trial, it's going to become clear, members of the jury, that to stay in the will, the defendant had to kill. You're actually going to meet Stevie Rogers today. And Miss Rogers is going to tell you how she reunited with her grandmother in the summer of 2018. She'll tell you that the morning of August 14th, her grandmother pulled her aside, locked the door, and said, Stevie, I'm writing you into the will, and I'm taking the defendant out of it. Miss Rogers will tell you that when she exited that room, she bumped into the defendant because the defendant had her ear pressed to the door, listening to every word of that conversation. Miss Rogers will tell you the night of that conversation, she saw the defendant go into Agatha's room holding something. And that just hours later, her grandmother was dead. And members of the jury, throughout this trial, you're also going to see some forensic evidence. And to show that too, you're going to meet Investigator Bond. And Mr. Bond is going to show you the evidence he found throughout his case. He's going to tell you that Agatha died because of an allergic reaction to a prescription drug called chloroandramine. Mr. Bond is going to tell you that he found chloroandramine, the substance that killed Agatha, in the defendant's closet, in a bag with the defendant's fingerprint on it. To stay in the will, she had to kill. Members of the jury, no matter how this lawsuit goes, no matter who wins, there's no bringing back Agatha Lee. But what we can do, what you can do, members of the jury, is not let the defendant profit off of an innocent woman's death, let alone a death that she caused. It'll be clear today that for the defendant to stay in the will, she had to kill. So at the end of this trial, my co-counsel, Katie Burdett, will ask that you find the defendant liable. Thank you.
Thank you. Is the defense prepared to make an opening statement?
Yes, Your Honor. May I proceed?
Whenever you're ready.
Your Honor, opposing counsel, members of the jury, may it please the court. Stevie Rogers framed Miss Mars to steal the fortune. Members of the jury, what happened to Agatha Lee is devastating. For the people close to her, that loss must weigh heavily. But throughout trial today, I want you to key in on that phrase, the people close to her. Because that's where the plaintiff's story starts to go awry. Just a moment ago, Ms. Rogers' attorneys on opening statement gave you their version of the story. Just like most stories, it held some bits of truth. It's true that Miss Mars had been Agatha's caretaker for over 10 years. It's true that over that time, Miss Mars and Agatha developed a special connection. And it's true that Agatha chose Miss Mars and not Stevie Rogers as the beneficiary in her will. But that's where the truth in the plaintiff's story runs out. Because you're going to hear today that when Stevie Rogers got desperate, when her bank account balance ran low, she sunk even lower. You see, what if I were to tell you that as of July 2018, it had been 7 years since Ms. Rogers had seen, spoken to, or visited her grandmother? What if I were to tell you that her return to Agatha's estate coincides exactly with her running out of money? And what if I were to tell you that the conversation Ms. Rogers claims happened between her and Agatha actually ended with her grandmother outright rejecting her begging for the estate? Stevie Rogers framed Miss Mars to steal the fortune. Now, I want to be very clear about what the law requires us to do today. First and foremost, you have to understand that the burden of proof rests entirely on the plaintiff's table. Today, as the defense, we don't have a responsibility to prove anything. Now, what the plaintiff has to prove to you by what we call a preponderance of the evidence, which means a story that is more likely true than not, is that Miss Mars either knowingly or purposely caused Agatha Lee's death. But as you're going to see today, the plaintiff will be unable to meet their burden. In fact, members of the jury, even though it isn't our responsibility, we're going to show you a much more likely explanation. We're going to do that in 2 ways. The first is we're going to show you all of the issues, all of the holes in the plaintiff's story, because there is one massive issue. Today, we're going to call 2 witnesses that will outright contradict Miss Rogers' explanation for the conversation she had with Miss Lee on August 14th. Outright contradict Miss Rogers' claims that she was being written back into the will. You have to ask yourself at this point, why would Miss Rogers lie? Which brings me to my second point. We're going to show you the much more likely explanation for how Agatha Lee died. Because members of the jury, you're going to learn that prior to this 2018 version of the will, Miss Rogers had been written out of an inheritance because of her distance and behavior. You're going to learn that Miss Rogers came back explicitly for money and that she would stop at nothing to get it. She framed Miss Mars to steal the fortune. And that's why at the end of today's proceedings, my co-counsel, Michael Young, is going to ask you to find in favor of Miss Mars. Thank you.
Thank you, Mr. Alexander. Let's see. Before the plaintiff calls its first witness, I'll ask everyone to switch to gallery view. That button is in the upper right-hand portion of your screen. This will allow you to see the attorneys and the witnesses at the same time. And is the plaintiff ready to call their first witness?
Yes, Your Honor. The plaintiff calls Miss Stevie Rogers to the stand.
All right, Ms. Rogers. Feel free to begin whenever you're ready.
Yes, Your Honor. Please introduce yourself to the members of the jury.
Hello, I'm Stephanie Rogers, but most people just call me Stevie.
Why are you here?
I'm here because I believe Drew Mars deliberately poisoned and murdered my grandmother, and I just can't let her get away with profiting off of my grandmother's.
Oh, I heard an objection.
Yes, Your Honor. To more prejudicial than probative.
I'm gonna, if you'd like to be heard further, sure.
Your Honor, this is only the second question we have in trial, and already this witness is testifying to the ultimate issue. Now, she can feel free to talk about her beliefs once we've had some foundation onto the record. But for her, 30 seconds into trial to say that she believes that Miss Mars did something deliberately to cause harm to Miss Lee is more prejudicial than it is probative.
I'm gonna overrule the objection at the moment.
Yes, Your Honor.
Feel free to re-raise the objection if you feel it's going too far afield. So it's fairly introductory at this point.
Miss Rogers, you were telling us why you were here.
Of course, I mean, I can't let Drew Mars get away with profiting off of my grandmother's death.
Who is Drew Mars?
She was my grandmother's live-in caretaker.
We'll talk more about the defendant later, but first I want to introduce the jury to your grandmother and your relationship to her. Your Honor, could we please put Exhibit 1 on the screen? It's already been entered into evidence.
Sure.
Could you describe your relationship with your grandmother to us?
Sure. Nana and I were really close, especially when I was young. She always used to tell me she saw a bit of herself in me. And so she'd always ask me what I thought about things, whether that was a book or the most recent game of backgammon or just what her thoughts were on the world. I mean, we were inseparable when I was younger, but we kind of lost touch at some point.
Why did you lose touch?
There's not really an easy way to say this, but while I was in college, I lost both of my parents to a drunk driver, and I just shut down. I kind of withdrew from everyone. I didn't visit Nana like I used to, and I just closed everyone out. Obviously, now that I know that the time was so short, I regret not spending the time I had with her.
Mr. Rogers, you were here during Mr. Alexander's opening statement, and he told us that you hadn't spoken to your grandmother in 7 years. Is that true?
No, I hadn't seen her in person in that time, but we called every so often, and I felt really connected to her still. I'd taken up writing, and since she and my mother were both writers, I felt like I was following in their footsteps, even if I didn't go and see her.
When was the last time your grandmother reached out to you?
The last time she reached out to me was in February of 2018. She sent me a letter and she told me that I was disinherited from her will.
How did you?
Apologies. Objection, Your Honor, to best evidence.
Would you like to be heard further?
Sure, Your Honor. The witness just testified about a letter she received from her grandmother. That letter is available in evidence, and if it's going to be referenced during trial, it should be entered so the members of the jury can see it.
Plaintiff's counsel like to respond?
Yes, Your Honor. The best evidence rule exists so we don't talk about or mischaracterize the contents of a document. Now, we're not going into the contents of the letter. All we care is that a letter was received. The only thing this witness said she learned was that she had been disinherited, which is a fact that's been stipulated by both parties in this case.
Yeah, Your Honor?
You sure? Yeah.
Your Honor, exactly, the witness did testify to the contents of that letter. And in order for the jury to fully explain the manner in which this witness was disinherited, they need to see the whole letter. It's why Rule 1002 exists.
Let me ask this. Do the parties expect to enter that document at any point?
The plaintiff is not going to be entering this document.
The defense expects to, Your Honor.
Okay, so let's do this. Why don't, so the objection is noted, but I think if the document is ultimately going to be brought into evidence, I don't think that it's an issue at this point in time. Feel free to raise that issue on cross-examination.
Yes, Your Honor.
Ms. Rogers, you just told us that you learned you'd been disinherited. How did you react when you learned that information?
I mean, I was hurt. I didn't realize how bad our relationship was at that point. I mean, we were still talking. I thought everything was fine, but I mean, clearly I hadn't done enough. So I knew I had to try to make it up to my grandmother.
What was your plan to try and make up with your grandmother?
Well, I knew I had to go visit her as soon as I could, and I told her I would on the phone. But I was away from the country at the moment. I was trying to finish up research for one of my novels in Peru, and so it took me a little bit to get back. But as soon as I did, I went about trying to find her.
Where exactly did you go?
Well, I went down to her house in Alabama, but she wasn't there anymore. She had moved, and none of the letters that she had sent me had return addresses, so I didn't know where to go. I knew I needed to find her. I needed to make things right, but I just didn't know where to start. So I ended up hiring a private investigator to try to locate her, and I finally found her.
What did you do when you found her?
I knew I needed to put in the time to repair our relationship, so I packed my bags and I headed down to her house. So nervous when I showed up at her door. I mean, I hadn't seen her in so long, even though we had talked. But as soon as she opened the door and saw me there, her face it just lit up. I can't ever forget that. And she opened up her arms in a giant hug and pulled me in. And she told me I could stay as long as I needed.
When did you arrive at your grandmother's house?
It was July 4th of 2018.
Besides your grandmother, was there anyone else staying at the house?
Yes, her caretaker, Drew Mars, was there with us as well.
How would you describe your relationship with the defendant prior to your grandmother's death?
I hate to say it, but it wasn't great. I mean, as soon as I got there, Drew kept asking me when I was leaving, and week after week, she just kept asking me. And she would always hover around Nana. I could never have alone time with Nana because after a couple of words, Drew would jump in and start her own conversation and then leave me alone.
What about your relationship with your grandmother? How did that change?
I mean, it was better than I even had hoped for. I mean, I knew that we had to fix things, but in the time that I was there, I mean, we were doing everything like we used to do when I was younger. It was like the time away meant nothing. It was nice to know that we had gotten to a good place finally.
While you were staying at her house, did the two of you ever discuss her estate?
Yeah, she brought it up one morning. I had brought her breakfast and we were just eating, but she told me that she was really happy that I had come back into her life, and she said that she was glad that we repaired our relationship. She was tearing up a little bit. I was too, but in that moment, she told me that she wanted to reinstate me in her will.
Objection, Your Honor, hearsay.
Yes, response, Your Honor? Yes, Your Honor. This statement is not hearsay because we're going to be using it for effect on the listener. Now, if I may proffer.
Sure.
The evidence will show, and this witness will testify, that the defendant was standing right outside the door in that conversation, that when Miss Rogers left, she saw the defendant react to what was going on. And therefore, the defendant overheard this conversation, and we're using it for the effect on the defendant. And Your Honor, furthermore, even if the defendant didn't overhear this conversation, it would be an exception under 8033 plan, motive, and intent, since Ms. Lee is discussing her intent to add this witness back to the will.
Response from defense counsel?
Yes, Your Honor. To the argument that this isn't being used for the truth, During their opening statement, the plaintiff talked at length about how motivation or about how money, specifically from these wills, was the motivation for Miss Marks to cause Miss Lee harm. At this point, they've provided no foundation as to the contents of any wills issued by Agatha Lee. The first time we're hearing about this is from this line of testimony, from the words of Agatha Lee, which are absolutely being used for the truth of the matter.
Would you like to respond to that, counsel?
Yes, Your Honor. Ultimately, it doesn't matter whether Miss Lee was going to add the plaintiff back into the will, Miss Rogers. What matters is what the defendant was aware of, and the fact that the defendant overheard this conversation. Oh, that's what we're interested today. That's the effect on the listener. And even if we were to use it for the truth, it would be an exception under 8033, like I mentioned earlier.
Anything further from the defense?
Your Honor, I stand by my objection argument.
Okay, the objection is overruled.
Yes, Your Honor. Miss Rogers, you were telling us about the conversation you had with your grandmother about her estate.
Yeah, basically she told me how much it meant to her that I was back in her life, and she told me that because I was her only remaining family, she really wanted to add me back into the will.
When did she tell you she was going to add you back to that will?
It was the morning of August 14th, 2018. And she also told me that she would talk to her lawyer soon after about making that change.
To be clear, Miss Rogers, did she tell you she was going to, or to what extent did she tell you she was going to add you back to the will?
She was going to reinstate me as her sole heir. That's what she told me that morning.
Do you know if the defendant was aware that your grandmother was planning on making you the sole heir?
I can't say for sure. All I know is that when we left that room after our conversation that morning, Drew was right outside the door, and her face, it was all red. She looked furious. She was glaring at me. She stared me down, and as soon as my grandmother passed me, she looked me dead set in the eyes and said, "No way."
After the defendant told you, "No way," what did you do for the rest of the day?
I didn't do much. It was a pretty normal day. I mean, Nana and I, we watched a movie. We hung out around the house. We had dinner around 6 o'clock. And at 9:30 that night, I said goodnight to my grandmother. And I told her that I loved her. And that was the last thing I said to her.
How did she seem when you saw her last?
Perfectly fine. I mean, she was walking around. She seemed really healthy. She looked normal.
Objection, Your Honor, to improper opinion.
Response?
Yes, Your Honor. Miss Rogers' testimony was rationally based on her perceptions under Rule 701. She regularly spent time with her grandmother. She's just telling us in her personal knowledge based on how she was viewing her grandmother, how her grandmother seemed to her. She seemed no different than she had those previous months. She was walking around fine. She seemed perfectly healthy. This witness is just testifying to what she saw. This is rationally based on her perceptions.
May I respond, Your Honor? The witness is free to testify to what she saw from her grandmother, whether she saw that she was walking fine, whether her energy was as normal, but for her to make the statement that she was perfectly healthy is an improper opinion.
Okay, yeah, I'm inclined to agree. I think that phrase in particular will be stricken from the record. Actually, why don't we do this? Why don't you go ahead and re-ask the question, and I'll instruct the witness to go ahead and answer based solely on your perception of kind of her condition, rather than making conclusions with respect to sort of her general health, because at least based on the foundation we've heard so far, it does not appear that she'd be able to make that. So objection is sustained.
Yes, Your Honor. Miss Rogers, how did your grandmother seem when you last saw her?
I mean, that night, she looked fine to me. She looked perfectly healthy, perfectly normal to me.
Did you see anyone else enter your grandmother's bedroom after you?
Yeah, after I said goodnight to Nana, I headed downstairs, and I was just sitting in our living room, and from there I could see Nana's door pretty clearly. And sometime around 9:35, 9:40, I saw Drew walk into her room. She had her hand clenched, like she was holding something. And then That's all I saw. I went to bed around 2 that night.
After you saw the defendant enter your grandmother's room with something clenched in her fist, did you ever see your grandmother alive again?
I'm sorry?
Objection, Your Honor, to attorney testifying. May I be heard?
Sure.
The witness testified she saw Miss Mars walking with a clenched fist and that it looked like she was holding something. But the attorney's question phrasing made it definitively that Miss Mars was holding something.
Okay. I guess here's what we'll do is, technically speaking, attorney questions are not considered evidence, but I would just ask counsel to please refrain from sort of extraneous comments, and certainly to the extent that witness's testimony is going to be used, please try and state it accurately. So I'm not going to rule on the objection, but I'm just going to ask counsel to abide by that.
Yes, Your Honor, I'll rephrase.
Thank you.
Miss Mars, when did you wake up the next morning?
It was at 8:35. I woke up to Drew banging on my door, and she told me that she found my Nana, that she found her not breathing. And so, of course, I ran to Nana's room to try to help, to try to do something, but I couldn't help. At that point, she was cold. And so I called 911.
Did you do anything else?
After that, I knew something didn't seem right. After I had seen my Nana and after the things that Drew had said to me, something seemed suspicious, something seemed off. So I called the detective I had used before as well.
Miss Rogers, did you have anything to do with your grandmother's death?
Of course not. Reuniting with my grandmother was the happiest moment I've had in the past 10 years, and I would never do anything to hurt her.
Oh, Your Honor, could we please put Exhibit 2 on the screen? It's already been entered into evidence.
Sure.
Miss Rogers, do you know what this is?
This is the toxicology report that they had on my Nana.
According to this autopsy, how did your grandmother die?
It said that she died from an allergic reaction to a drug called chloroandramine.
Do you know if your grandmother regularly took any medications?
I know she took some every night, around 10:30 at night, but I don't know exactly what she took.
Besides your grandmother, are you aware of anyone else that had access to her medication?
Yeah, her caretaker, Drew Mars. I mean, she filled up her pills every Saturday and she put the pill organizer on Nana's nightstand. I even saw Drew filling the organizer a few times while I was there.
Earlier, you said you had a conversation with your grandmother about reinstating you as sole heir to her estate. Do you know if she had changed her will before she'd passed away?
No, we had just had that conversation the morning before.
Based on her will at the time of her death, do you know who is set to inherit all of your grandmother's estate?
Drew Mars's.
Thank you. I have no further questions at this time.
All right. Cross-examination,
Yes, Your Honor. May I proceed?
please.
Good afternoon, Miss Rogers.
Good afternoon, sir.
I want to start by talking to you about the wills that your grandmother issued, okay?
Okay.
Now, the will that she issued in February of 2018 was not her first, correct?
No, she had already made one naming me as her sole heir.
All right, I just want to break that down a little bit. So in 2008, she issued her first will.
Yes, sir, that's correct.
And in that will, you were named the sole beneficiary, right?
Yes. It was right after my parents passed and she named me. Yes.
Now I want to fast forward to 2011, okay?
Okay.
In 2011, you were in law school, right?
Yeah, but I wasn't doing so hot.
That was the last year you were in law school?
Yeah, I was struggling on keeping up with my classes and my work. And I wasn't really leaving the house and I ended up dropping out. Yes.
I appreciate that answer, Miss Rogers, but just for the record, that was the last year you were in law school?
Yes. that was the last year.
Now, Ms. Rogers, between the years of 2011 and 2018, you didn't visit your grandmother at all, right?
No, I didn't realize I was closing myself off from her, but I didn't go see her in person in that time.
In those 7 years, Ms. Rogers, you remember calling your grandmother one time.
Yeah, I didn't call her that much. She called me a few times, and we would talk every once in a while, but not often. I'll never forgive myself for that.
Ms. Rogers, I understand that's what you're saying now, but to be clear, you remember speaking over the phone with her one time between 2011 and 2018?
No, I called her one time. I was bad at making the phone call. Obviously, I didn't realize that I wasn't reaching out, but I wasn't. But she continued to call me for some reason.
And I wanna make sure I'm clear about when you did call. On direct examination, you said you called her after you received the letter in February 2018?
I didn't say that, sir. She called me. I didn't call her. I only called her on her birthday that one time.
I wanted to clear that up then, Ms. Rogers. So the only time you remember calling your grandmother in those 7 years was in 2017?
Yeah, I was traveling a lot. It was hard for me to find a time to call her, so she usually called me, but I'd pick up and answer.
Now, you mentioned on direct examination that your grandmother moved during that time. Is that right?
She did.
You didn't know about that move?
No, I don't know why she didn't tell me. Obviously, she thought our relationship was a lot worse than I did.
Before hiring a private investigator, you weren't even sure what state she was living in.
Well, I thought I knew what state she was in, but obviously once she moved and I didn't know where she was at, no, I didn't.
And that's why you eventually hired a private investigator to locate your grandmother's address.
Yeah, I knew I had to find her. I had to make it right with Nana. I could not forgive myself if I just let our relationship suffer like that.
Now, I want to talk to you about the letter that you mentioned on direct examination.
Okay.
You received this letter in February of 2018, right?
Yes, sir, that's correct.
You told the members of the jury that it hurt you reading that letter, correct?
Yeah, it did.
You said that it made you want to fix your relationship with your grandmother, correct?
Yeah, I mean, I didn't realize that's how she saw it. I thought we were fine. I mean, we were still talking every once in a while, but obviously I hadn't done enough and I knew that needed to change.
Ms. Rogers, I just want to bring you back to my question. That letter made you want to fix your relationship with your grandmother, yes or no?
It did.
Your Honor, permission to show this witness outside of the eye shot of the jury exhibit 10. It hasn't been entered into evidence to this point.
Sure, that's fine.
Ms. Rogers, that right there on your screen is exhibit 10, correct?
It appears to be, yes, sir.
It's the same letter that we were just speaking about before.
Yes, the one I got from my grandmother in February of 2018.
It hasn't been altered in any way.
Not that I can tell, no, sir.
Your Honor, at this time, the defense offers exhibit 10.
Any objection?
Yes, Your Honor, an objection to hearsay.
Would you like to be heard further, or well, actually, why don't we do this? Counsel for defense, can you go ahead and respond?
Yes, Your Honor. As the previous line of questioning shows, we're not offering the statements within this letter for the truth of the matter asserted, and rather for the subsequent action of Ms. Rogers. She told us on direct examination and now again that she reacted to this letter and it made her want to improve her relationship with her grandmother.
A response?
Yes, Your Honor. They don't need this letter to show that response. Ms. Rogers has already said that she saw this letter and she wanted to fix her relationship. They already got that effect. They don't need this letter to show it. The only reason you'd show this letter is to try and prove the truth of the statements within this letter. If I may proffer, Your Honor?
Sure.
The contents of the letter, it's on the screen. Statements like you're still treating grandma as your own personal ATM to fund whatever pops into your head next. Statements like these, the defense is entering this letter to use those statements for the truth. We already have the effect. We already have the testimony. She's trying to fix the relationship. They don't need these statements to show that.
And I'll give defense counsel one last response.
Yes, Your Honor. Your Honor, the plaintiff is trying to say that this letter made her want to improve her relationship with her grandmother. But it's important to note that this letter was sent in February, and she didn't visit until July. The actual words that her grandmother spoke to her are critical for the jury to see so that they can understand the timeline with which the plaintiff was responding to the words of her grandmother and when her actions actually followed.
May I be heard on those grounds, Your Honor?
Very briefly.
If they just care about the timeline, they don't need the statements. Just saying a letter was sent in February is enough to demonstrate that timeline. The only reason they're entering these statements is for the truth of the matter asserted.
Okay, well argued by both sides. I'm going to go ahead and admit the document with a limiting instruction to the jury that this is not to be taken for the truth of the matter asserted, but rather to be used for the effect upon this witness in particular after reading this document.
Yes, Your Honor.
Yes, Your Honor. May I proceed?
You may.
Now, Ms. Rogers, I just want to ask you about a few of the things your grandma told you in this letter, okay?
Okay.
Now, in the third paragraph, she tells you that you are still treating your grandma as your own personal ATM, correct?
Yeah, I didn't know she felt that way about our relationship, and it hurt.
Later on, she mentioned that she was actually writing you out of her will, correct?
She did. That showed how broken she thought ours was.
She said specifically that her mind was made up, that she had thought deeply about it.
Yeah, she said she felt like we were family in name only now. I can't believe that that's what she thought. That's why I knew I needed to change things. And that's why I tried to get back to her as fast as I could.
Ms. Rogers, I just want to make sure I got the sentence that I was asking you about clear. She told you that she had thought deeply about this decision and that her mind was made up, yes?
Yes, she said that.
Mr. Young, you can take the exhibit off the screen. Again, Ms. Rogers, this was sent in February.
Yeah, and that's when I knew I needed to get back.
You didn't visit your grandmother until July.
Yeah, I mean, I was stuck in Peru for a little bit. I was trying to wrap things up on my research, so I wasn't back in the States for a while. By the time I got back, I didn't know where to find her.
Ms. Rogers, I'm sorry to cut you off, but I need a yes or no answer to my questions, okay? You visited
Okay.
your grandmother in July, correct?
That's when I finally located her after I was looking, yes.
You didn't start looking for your grandmother until June, isn't that right?
Well, yeah, I thought I knew where she was. I thought she was still in Alabama. She hadn't told me where she had moved.
Yes or no, Ms. Rogers, in June is when you started looking for your grandma?
Yes, sir. That's when I started looking for her.
Also in June, Ms. Rogers, your trust fund ran out, isn't that right?
The money my parents had left me ran out then. Yes, sir.
Right, in 2008, you inherited $2 million in the form of that trust fund.
Yes, after my parents passed.
And in June 2018, it ran out.
Yeah, I still had other money that I could live off of, but all of that money from that account was gone.
So within a month of your running out of this trust fund money is when you went to visit your grandma, yes?
That is the time, but that wasn't my main concern. I was fine on money. I wasn't sweating it. I knew I had to change our relationship.
Yes or no, Ms. Rogers? That was a month after?
Yes, July was the next month.
Now, Mr. Rogers, I want to talk to you about this conversation you testified about on August 14th, okay?
Okay.
Now, following that conversation, you didn't send anybody text messages about what your grandma had told you, right?
No, it was something deeply personal to me. Why would I be telling people about it? It's not something to brag about. It was something my grandmother told me in confidence.
Rogers, I just need a yes or a no to my question. You didn't send any text messages about it?
Of course not.
You didn't send any emails about it?
No, sir.
On August 14th, you didn't tell anyone that you had that conversation with your grandmother?
I did not.
Now, Ms. Rogers, on direct examination, you talked about an allergy your grandmother had, correct?
Yeah, the one Drew told me about.
That was to a pill called chlorandramine?
Yes, sir.
I want to be clear, you knew about that allergy, right, Ms. Rogers?
Yeah, Drew had mentioned it to me one day out of the blue that Nana was allergic to it.
To be clear, though, you were aware that your grandmother had this deadly allergy?
Yes, because Drew told me about it.
Thank you, Ms. Rogers. I have no further questions at this time, Your Honor.
Any redirect?
No redirect, Your Honor. We just ask that Ms. Rogers be allowed to step down.
Of course. And is the plaintiff ready to call their second witness?
We are, Your Honor.
Go right ahead.
Yes, Your Honor. At this time, plaintiff calls Investigator Bond to the stand.
And counsel, feel free to begin whenever you're ready.
Yes, Your Honor. Could you please introduce yourself to the members of the jury?
Good afternoon. I am M. Bond.
We're going to need your full first name for the record. Is it just M?
Yes, one letter, efficient, to the point, distinctive, ideal for my line of work.
And Mr. Bond, where exactly are you calling us from today?
My office, as you can probably see, I prefer to work by lamplight. I find that it focuses the mind.
All right, Mr. Bond, what exactly do you do for a living?
I'm a private investigator, sir, and the operative word there is private.
What do you mean private?
If you've ever looked at the front page of a tabloid, you've probably seen all manner of nasty gossip. And those stories don't win Pulitzers, but they sell. Clients who want their cases solved without that sort of publicity, they hire me.
Okay, so how did you become involved in today's case?
On the morning of August 15th, 2018, I got a call from a Miss Stevie Rogers. She said that her grandmother, Agatha Lee, had been killed, and she was counting on me to investigate the death.
Did she pay you for that investigation?
Yes, I was paid my standard fee, sir. $25,000 for my work.
And did getting that money, does that depend on you reaching a certain conclusion or testifying in any sort of way today?
No, sir, it's a flat fee.
Okay, so after you got that call from Miss Rogers, what did you do?
I had my driver bring me to Lee Manor, where Miss Lee and Miss Rogers had lived together, and thus began our investigation. First, looked to the means, how Agatha Lee, and if appropriate, we knew we could continue to motive.
Okay, so means and motive, we'll take those one by one, starting with means. How did you determine how Agatha Lee died?
Well, of course, we had to start by inspecting her body, sir.
Did you notice anything about Agatha Lee's body?
Not at first. Agatha looked almost peaceful. No bruises or scratches, no clear signs of struggle. But of course, looks can be deceiving. I've learned in my years that there are murder weapons that are undetectable at first glance. A drop of poison in the evening drink, a prick from a syringe, an innocent-looking pill at bedtime. And that's why Miss Rogers and I requested an autopsy and a toxicology screen when the police arrived.
Did the police agree to conduct that autopsy and the toxicology screen that you and Miss Rogers requested?
At first, no. Detective Khan, the police's lead investigator, was well-intentioned but a little naive. She suggested that because Agatha Lee was an old woman, the death was probably natural causes and the body should be taken to a funeral home. At that point,
Substantially more prejudicial than probative, referring to Detective Khan as naive.
I'm sorry, you broke up there. What was the objection one more time?
Under 403, the characterization of Detective Khan as naive being substantially more prejudicial than probative.
Would you like to respond, counsel?
Yes, Your Honor. In order to be excluded under Rule 403, the prejudicial value has to substantially outweigh the probative value. The probative value here is that the police did not look into whether or not this was a murder, and if I may proffer,
Sure.
This witness is going to testify that in fact was naive because Miss Lee had died not of natural causes like the police suggested. Additionally, this doesn't prejudice the jury in any way just by Mr. Bond calling the police naive because they didn't look into all options. And therefore, it doesn't meet the standard of Rule 403.
Okay. Yeah. I think the objection is noted, and I would say that perhaps that's something you may want to get into on cross-examination, but I'm going to overrule the objection.
Yes, Your Honor.
Mr. Bond, you were talking about how the detective wanted to rule this death a natural cause.
That's right. The detective said that because Agatha Lee was old, the death was probably natural causes. And at that point, Miss Lee's caretaker, Drew Mars, she spoke up and she went further.
What do you mean the defendant went further?
Well, Miss Mars said that we ought to cremate the body. We ought to turn it to ashes. And she said that that's what Agatha Lee would have wanted.
Well, if Agatha's body had been cremated like the defendant wanted, would it have been possible to perform an autopsy on it?
No, sir.
What about a toxicology screen?
As you may have guessed, you can't do that on ashes either. Fortunately, cooler heads prevailed. Police eventually agreed not to cremate the body and to conduct both tests.
Would you actually recognize that autopsy if you saw it today?
Yes, sir.
And Your Honor, if we can get Exhibit 2 up on the screen, it's been pre-admitted.
Sure.
What are we looking at here, Mr. Bond?
This right here is the autopsy of Agatha Lee, the document that proved me right in determining that she didn't merely die in her sleep of natural causes. Actually, if you can zoom in to the results section, the conclusion.
Of course, Mr. Bond. What does the autopsy list as the cause of death?
An allergic reaction to 2 pills of a drug called chloroandramine.
Do you know if anyone was aware that Miss Lee had this fatal allergy to chloroandramine?
Yes. Drew Mars actually told me about this allergy, and Miss Mars said she knew it was a potentially deadly allergy.
Do you know if Miss Lee took any medicines on a regular basis?
Yes, sir, she did. And as a matter of investigation, I inspected all of them. In fact, one of them, her arthritis medication, is basically identical to chloroandramine.
Objection to lack of foundation in this testimony. We'd ask that the witness lay some foundation as to how they know this information.
Would Your Honor like me to respond?
Sure. I'm sorry. What was the question? I just want to make sure I have it clear in my head.
Your Honor, I asked the witness if Agatha Lee, if he knew that Agatha Lee took any medications. He said yes, that she did.
Okay. And so, counsel for defense, the objection is a lack of foundation.
Yes, Your Honor. We have heard the answer that the witness was giving includes no information on how they knew about this information.
Okay. Sure, I'll sustain that. Counsel, if you could go ahead and lay a little foundation before getting into sort of what the details are of the information.
Your Honor, he was just about to say that. We can do that.
Okay, thank you.
Mr. Bond, you were talking about Agatha's arthritis medication. Could you describe that?
Yes, like I said, I inspected that medication along with the rest of them. I looked at the pills and actually ingested them. That pill was the same size as the chloroandramine pill, the same color, the same shape. Both, of course, are odorless and tasteless. One of them would kill her.
I'm sorry, Mr. Bond, could you repeat that last sentence? I think you cut out.
Of course. The only difference between the chloroandramine and the arthritis pills, upon my opinion, is that the chloroandramine pill is lethal for Agatha Lee.
Do you know who is in charge of giving Agatha Lee her medication every day?
Yes, that was Drew Mars's job. This in total was strong evidence linking Drew Mars to the means.
Okay, so you said that chloroandramine was the cause of Agatha Lee's death. Did you ever search her house for that substance that killed her?
When I first arrived at Lee Manor, I conducted a complete search, with one exception. Drew Mars would not let me enter her bedroom, so I couldn't search either the bedroom or the closet. Fortunately, the police do not serve at Drew Mars's request, so a week later, when the police got a warrant, they searched Drew Mars's bedroom and closet, and they were wise enough to bring me along.
Did you find anything in the defendant's bedroom when you got a chance to search it?
We did. We found a black bag with a bottle of pills inside of it.
Do you have the picture of that bag and a picture of those pills in front of you, Mr. Bond?
I do.
Do they seem to be fair and accurate depictions of the objects in those pictures?
Yes, they are.
At this time, Your Honor, plaintiff moves to enter exhibits 15 and 17 into evidence.
Any objection? I'm sorry.
Without objection, Your Honor.
They'll be admitted.
All right, Mr. Bond, let's start on the bag. Do you know if there was any forensic evidence on the bag found by the police?
Yes, the police were able to find one usable fingerprint on the pull zipper of the bag.
Objection, Your Honor, again, to lack of foundation as to how this witness is aware of this fact.
May I respond, Your Honor? Your Honor, in the stipulations with opposing counsel agreed to, it's already been stipulated that Mr. Bond can testify to the contents of the police report. We don't need to lay any foundation because it's already been stipulated.
Is that correct?
Yes, Your Honor.
Okay.
However, while Mr. Bond can testify to the contents of the report, we would like to see more foundation on. We would like to see foundation on how this witness is aware of this fact.
Um,
Respond, Your Honor,
Sure.
quickly. Your Honor, he just said he read the police report.
yeah, I'm gonna go ahead and allow it. The objection's overruled.
Yes, Your Honor.
Mr. Bond, do you know if the police found any forensic evidence on that bag?
Yes, there was one usable fingerprint as with the police report, and it was found on the pull zipper of the bag.
And do you know if the police were able to determine whose fingerprint that was?
Yes, again, per the report, that was a 16-point match to the fingerprint of Drew Mars.
Okay, how about those pills found in the defendant's closet in a bag with the defendant's fingerprint? Do you know if the police were able to identify what those were?
Yes, sir. According to their toxicology report included within that police report, these pills were chloroandramine, and that's the same substance that killed Agatha Lee.
Okay, then besides that bag containing chloroandramine, did you find the defendant's fingerprints anywhere else?
Yes, actually. Looking at the medicines in Agatha Lee's bathroom, there were the defendant's fingerprints on 2 pills of the arthritis medication. That's Winterin.
How many pills of chloroandramine, the drug that you said was identical to Agatha's arthritis medication, were used to kill Agatha Lee?
Very good. That's exactly the question I'm asking. And sure enough, it matches. 2 fingerprints on the arthritis pills, 2 chloroandramine pills used to kill Agatha Lee.
All right, Mr. Bond, I want to move on, shift gears a little bit, and talk about Agatha Lee's finances. Were you aware of how much her estate was worth?
Yes, $20 million in cash, a $2 million mansion with no debt in it, and then $3 million in royalties. So that's $25 million in total.
And do you know if she had a will that would distribute those assets when she passed away?
She did, effective of February 2018.
And do you have that will in front of you, Mr. Bond, Exhibit 9?
Yes, sir, I do.
Is it a fair and accurate copy of Agatha Lee's will in 2018?
It is.
And can you see if Agatha Lee signed that will?
She did, sir.
At this time, Your Honor, plaintiff moves to enter Exhibit 9 into evidence.
Any objection?
No objection, Your Honor.
It'll be admitted.
All right, Mr. Bond, this will, what does it say?
It says that when Agatha Lee died, she was going to leave her entire estate, that $25 million estate, to the defendant, Drew Mars.
Was this will ever read to people in the case?
Yes, and I ensured that I was present for that will reading.
Why did you want to be present for the will reading?
Well, the Shakespeare fans may recall Act 3, Scene 2 of Hamlet. In that, Hamlet's state is a reenactment of his father's death, with the goal to elicit a reaction, to see who in the audience shows guilt or fear. I was actually doing the same thing here. I wanted to see if anyone had a strong reaction to the will reading.
So when the will reading happened, was there any strong reaction that you saw?
Yes. When I got to the section that said that Drew Mars would receive all of Agatha Lee's assets, Miss Mars said repeatedly, almost theatrically, "I had no idea."
The defendant saying she had no idea to finding out that she was the sole heir to Agatha's assets. Do you know if that was true?
Well, I actually soon found reason to believe that was untrue.
What was that reason that you found?
I acknowledge that at this stage I did something a little unscrupulous, perhaps running all of professional norms. Certainly my mother was unpleased, but I'm unshakable in the pursuit of truth. I accessed Drew Mars's email from her laptop, and I found a message that contradicted the claim.
Do you have that email in front of you?
I do. A picture I took off the email.
Is it a fair and accurate picture, same as you last saw it?
Yes, sir.
At this time, Your Honor, plaintiff moves to enter Exhibit 13 into evidence.
No objections, Your Honor.
It'll be admitted.
All right, Mr. Bond, when was this email written from the defendant?
This is in February 2018, 6 months before Agatha Lee died.
And in this email, what does the defendant say?
Well, Miss Mars says that Agatha Lee told her that she was changing the will to leave everything to Miss Mars, which makes it hard to believe that, as she claimed, Drew Mars in fact had no idea she wasn't inheriting all of the money.
Now, earlier you mentioned that at the start of this investigation, the police were going to rule this natural causes, and then Miss Mars wanted the body cremated. If all that had happened, According to the will, who would have gotten Agatha Lee's estate?
Drew Mars.
Thank you, Mr. Bond. Your Honor, I have nothing further for this witness.
Cross-examination.
Yes, Your Honor. If I may just have one moment to change cameras.
Of course, take your time.
May I proceed?
Yes.
Good afternoon, Mr. Bond.
Good afternoon, sir.
Now, I'd like to start by talking about your relationship with the plaintiff because, as you said on direct, this isn't the first time that the plaintiff has hired you, correct?
No, I was hired by Stevie Rogers a few months before this particular assignment and paid $10,000 to find Agatha Lee, Miss Lee, of course, being a noted recluse.
Right. And in this case, the plaintiff has promised you an extra $25,000, correct?
Right, she's paid me $25,000.
So is your testimony that you have already been paid that $25,000?
Yes, I was paid $25,000 shortly after I made that speech in the drawing room, sir.
Let's see. Now, Mr. Bond, I'd like to talk about your investigation. So you were made aware of this case on August 15th, correct?
Right, that's when I got the call from Stevie Rogers.
Right. And you arrived before the police, correct?
That's correct.
Right. And after Detective Khan arrived, you went to go speak with the plaintiff, correct?
Yes, sir.
Right. And you discussed Agatha Lee's will.
Of course, that's a hot topic in this case, obviously.
Now, Mr. Bond, in that discussion, you never mentioned chlorandramine, did you?
In the initial discussion, no, sir. We learned that chlorandramine was the killer substance after the toxicology report came back.
Right. And after you got that toxicology report, you never brought up chlorandramine with Miss Rogers, did you?
What do you mean brought up chlorandramine with Miss Rogers?
You never talked to Miss Rogers about whether they knew if Agatha Lee had a chlorandramine allergy, did you?
No, sir. The toxicology report was disclosed to both of us. Not speak to Miss Rogers about the findings of that report.
I see. And sometime after that, you talked to Miss Mars, correct?
Yes, sir.
And you discussed Miss Lee's chlorandramine allergy.
That's correct, sir.
Now, Mr. Bond, at no point in that conversation did you mention Miss Mars's financial circumstances, did you?
I did not bring up Miss Mars's financial circumstances while talking to Miss Mars, sir. That seemed rather insensitive given the situation.
Right. And over the course of that investigation, you never looked at Miss Mars's financial statements.
No, sir. Miss Mars didn't let me search her room, let alone offer me her financial statements. She was less than cooperative.
Right. And you didn't look at Miss Rogers' financial statements either, did you?
No, sir. There's, of course, a reason for that.
Right.
And I can tell you if you'd like.
No need, Mr. Bond. Now, you just told us that will was a possible motive for this incident, didn't you?
A clear motive. Yes, sir. $25 million. A lot of people do some pretty terrible things, unfortunately.
So in a case with a financial motive, of the two people in the house, you didn't ask if either of them had a pressing financial need, did you?
Right, sir. And again, there's a reason for that, and I can explain it to you if you'd like.
There's no need, Mr. Bond. Now, I'd like to talk to you about a search you did that day, because to be clear, when Miss Mars said that you could not search her room, you went in anyway, didn't you?
At a later point, not immediately, sir.
Right, but it was on August 15th, wasn't it?
Right, that I searched and I saw the laptop. Yes, sir.
Right. So you went in there without notifying Detective Khan, right?
That's right. One of the clients hire me is that they trust that there are things that I can do, that I'm willing to do, that perhaps the red tape of law enforcement does not permit. This was one of those instances, sir.
So to be clear, you were alone in that room, correct?
Yes, sir.
Right. And nobody could see you from outside that room?
I have no idea.
All right. Now, and when you found that email, you didn't tell Detective Khan, did you?
I certainly told Detective Khan. I told all parties involved in this investigation.
Well, you told her that on the 22nd, didn't you?
Right, at the point that I gathered everyone involved in this investigation, sir.
Right. Now, you'd agree with me that in an investigation, it's important to have all the facts, correct?
Certainly. I was running my investigation. Detective Khan was running hers. Fortunately, I was able to get to the right answer a little quicker. That's what my clients pay me for.
Right. And when you had this evidence, so you're telling us that you didn't turn this over to Detective Khan until a week after.
Right. I was not working for Detective Khan, sir. I was working for Stevie Rogers, and specifically, I was conducting an independent investigation. That's what I was hired for, sir.
Okay, so to be clear, you were not, so in this instance, you were not helping the police to investigate this crime, were you?
I certainly helped the police investigate this crime, sir. If I may leave off modesty for a second, I would say that I solved the bulk of it for them.
All right. Now, just one last thing, Mr. Bond. Just to be clear, I want to talk to you about the search you did 6 days after August 15th. Now, you found chloramine in the defendant's closet, correct?
That's right, in a bag with Drew Mars's fingerprint.
All right, but to be clear, that bottle that the chloramine was in, that didn't have the defendant's fingerprints, did it?
Right, there were no traceable fingerprints on the bottle, sir.
Right, and this was 6 days after Agatha Lee was found dead, correct?
Right, it was at that point that the police obtained the warrant to search Drew Mars's room.
Thank you, Mr. Bond. No further questions, Your Honor.
Any redirect?
Just a couple questions, Your Honor. Mr. Bond, just a minute ago, Mr. Young asked you a couple questions about the finances of Stevie Rogers and the defendant, and I want to give you a chance to explain. Did you find any financial reasons for either of those parties to commit this crime?
Right, as I was going to tell Mr. Young, when there were $25 million at stake, the financial peculiarities of a given suspect aren't all that relevant. $25 million motivates a lot of people. That's a pretty universal motive.
Thank you, Mr. Bond. Nothing further, Your Honor.
And any recross on that very limited redirect?
Briefly, Your Honor.
Go ahead.
Just to be clear, Mr. Bond, you don't know if Ms. Rogers has any outstanding debts, do you?
No, sir. Again, like I said, I did not look at the financial statements of any of the parties in this case. That was needless in this investigation, and Drew Mars didn't cooperate on that front.
Thank you, Mr. Bond. Nothing further, Your Honor.
All right. May this witness step down?
Of course, Your Honor. And at this time, we rest our case in chief. We just ask for a brief recess before the defense proceeds.
Okay, thank you. So the plaintiff's case has been rested. We will now take a 5-minute break. Judges, please remember that this video is being publicly broadcast via YouTube live stream. See you all again shortly. My timer shows it's 12:57. Why don't we come back at 1:05 p.m. So let's make it 8 minutes rather than 5.
Judges, if you don't mind, as you're coming in, if you could just send me a private message or turn your camera on and just let me know that you're back, we can check you guys off and get started smoothly. Awesome. I think if we just get confirmation from Ian, we should be good to go.
I'm back. The
Got
chat
you,
wasn't
Ian.
working.
Awesome. All right. Teams, can you just confirm that we have everyone here? It looks to me like we do.
Yeah, I believe everyone from the plaintiff is present, Your Honor.
Awesome. Let's get going then.
And everyone from the defense is present, Your Honor.
Great. So everyone's back and ready to go. Then let's have the defense please call your first witness.
Your Honor, before we do so, permission to read a stipulation onto the record.
Sure, unless there's an objection.
No objection, Your Honor.
Go right ahead.
Yeah, this is stipulation 26 on page 2 of these stipulations. This should be in your bench book. Chlororandramine is an inexpensive over-the-counter medication that is used to treat heartburn and can be purchased without a prescription or identification from at least 15 locations in Ryder County, as well as in Ryder County Midlands, as well as over the internet.
Okay.
And with that, the defense calls Ryan Cabrera to the stand.
Alrighty.
May I proceed?
You may.
Good afternoon, Ms. Cabrera. Could you please state your name for the court?
Hi, my name's Ryan Cabrera.
And Ms. Cabrera, what do you do for a living?
I'm a writer, biographies mostly about famous writers. It's kind of meta. I've done Bram Stoker, Mary Shelley, and recently for a lighter project, I did Sylvia Plath.
And in your career, did you ever write about someone named Agatha Lee?
Yeah, I was working on a bio about her, so I shot her an email to meet up. It turns out she was even more of a hermit than I am because it took her 3 years to respond, but she told me she was in Midlands, so I moved like the next day.
Just for the authority of the court, when you say the next day, do you know when, or when do you mean?
That was February 2018. I just didn't have much going on in my life.
Now, Ms. Cabrera, could you describe your initial relationship upon meeting Miss Lee?
Yeah, we met like every week. She was fine. We would do stuff together, like talk or eat, play with my Ouija board, or we went on a walk once.
So during this time, do you believe that you were friends with Miss Lee?
Yeah, I guess you could call us friends.
I see. And during these first few weeks, was anybody else living at Miss Lee's house?
Yeah, Drew Mars. Agatha was old, so Drew took care of her. She'd been there for like 10 years.
I see. And was there anyone else? Did anybody else ever move into the house?
Yeah, that was July of 2018. The grandkid, Stevie.
I see. And can you describe the relationship between Stevie and Miss Mars?
Well, Mars kept complaining about how Stevie seemed to just be there for the money. They didn't seem to get along to me because Mars didn't trust Stevie.
Objection, Your Honor, lack of personal knowledge. to the statement that Mars didn't trust Stevie?
A
Can I
response?
respond, Your Honor?
Okay.
Your Honor, the witnesses testified that they had met with Miss Lee over the course of several weeks. This was more than enough time for them to generate an observation that was rationally based on their perception.
I think as phrased, I think I'm going to sustain that objection. Go ahead and feel free to ask it in a different way.
Move to strike that testimony, Your Honor.
Sure.
Yes, Your Honor. Now, Ms. Cabrera, I'd like to take a step back with your conversations with Miss Lee. At any point, did the topic of her wills ever come up?
Yeah, I'd asked because it's kind of morbid and kind of my thing. She showed me her wills over the years. So there was two, I think, one in 2008 and one in 2018.
And would you recognize those if shown to you today?
Yeah.
Mr. Alexander, if you could please pull up exhibits 8 and 9.
Apologies, I'm having a technology issue.
Okay. All right. I guess we'll hang on until hopefully it gets resolved.
Apologies, Your Honor.
Oh, no problem. That's sort of the nature of how these things go these days. Are we all set? Technology stuff averted?
I believe so.
Okay, perfect.
So, Ms. Cabrera, can you just confirm what Mr. Alexander has put on the screen here?
Yeah, there's two wills. One is the 2008 one when she still had Stevie in it, and then the 2018 one when she did a 180 and left everything to her beloved and devoted and beloved caretaker, Drew Mars.
And just to clarify, Stevie Rogers is referring to the other person who you said moved into the house?
Yeah, the grandkid.
Okay. Now, Mr. Alexander, you can stop the screen sharing. Now, Ms. Cabrera, I'd like to talk to you about the events of August 14th. When was the last time that you saw Miss Lee alive?
The day-ish when she passed, actually, that day, August 14th, we got lunch.
Let's see. And did anything happen during that lunch?
We talked. I was still, interviewing her for the bio. She seemed a little different though. She was like quieter. So we started talking about Stevie at one point.
And what did Miss Lee say about Stevie?
She talked about how she wanted Stevie to forgive her, that she hoped she made the right decision.
Did you ask her what that decision was?
Yeah, because she didn't say, right? So I was like, what exactly did Stevie ask for? Like, why did she need that kid's forgiveness? But she didn't say, and she just changed the subject to like opera.
Let's see. Ms. Cabrera, did you ever figure out what Stevie was asking about?
No, because she died like that day. Drew was crying super hard on the phone when she told me. So I was like, there. But Drew just told me, don't be sarcastic. But I mean, I wasn't. I am sad that Agatha died because she was like cool.
Thank you, Ms. Cabrera. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Oops, excuse me one moment. All right. Miss Cabrera, I have a few more questions for you, and then you'll be free to leave. Can you see and hear me okay?
Cool. Yeah, you're good.
I want to talk about that, where you left off, that a meeting you had with Miss Lee on August 14th, 2018, okay?
Yeah.
She told you that she was planning on meeting with her attorneys that Friday, right?
Objection, Your Honor, to hearsay.
Your Honor, if I may be heard? This is a hearsay exception under Rule 8033, of which deals with plan, motive, or intent. She's telling Ms. Cabrera that she's planning on meeting with her attorneys on Friday. That's a hearsay exception under 8033.
Your Honor, if I may be heard on those grounds.
Sure.
Your Honor, I believe that there is truth value beyond simply a plan here, and that there was truth value in the fact that this appointment was made and scheduled.
Could you elaborate a little bit further, counsel?
Yes, Your Honor. This is going into, we believe that by describing Ms. Lee's conversation about this plan meeting with their lawyer, there was truth value in the fact that this plan was scheduled with this lawyer.
Would you like me to respond, Your Honor?
Sure, go ahead.
We're not saying that the statement isn't hearsay. We're not trying to say there's no value to the statement. We're saying it's a hearsay exception under 8033, that since this statement is dealing with a plan to meet her attorney on Friday. Therefore, it is an exception to hearsay and is admissible.
Okay, I'm gonna overrule the objection.
Yes, Your Honor.
Yes, Your Honor. Ms. Cabrera, during that lunch, Miss Lee told you that she was planning on meeting with her attorneys that Friday.
She mentioned that.
You're aware that Miss Lee's attorneys were in charge of her will.
Yeah, apparently you need a lawyer for that.
But you know that Miss Lee never got a chance to meet with her lawyers that Friday.
Yeah, because she was dead.
I want to talk about why you're here today, Miss Cabrera. The defendant actually asked you to testify.
Yeah.
Depending on the outcome of this case, you stand a lot to gain.
I'm not sure what you mean.
Well, you're aware that Miss Lee was a best-selling author, right?
Yeah, Death in a Bottle. I've read it like 20 times.
You actually halted everything in your life to move to Midlands for the chance to write her biography.
Oh, I was between projects, like I said, not much going on, so I moved.
Well, you're aware that she has only written one book.
Right, Death in a Bottle.
She wrote that in the 60s.
Yeah, it's old.
It sold over 65 million copies worldwide.
That is a fact.
But she never published any other books.
Yeah.
During your conversations with Miss Lee, you kept asking her why she didn't publish any other books.
I wasn't annoying about that because the first time we met, Agatha said, literally ask me anything except that question.
But you were wondering why she hadn't published any books since her first was so successful.
Yeah, I don't blame her for becoming famous and then becoming a recluse. I would do that too.
Miss Cabrera, you're aware that Miss Lee actually wrote dozens of unpublished works.
I found that out at that last meeting. She just brought it up.
To your knowledge, you're the only person that knows about that.
Yeah.
You cannot fathom how much those unpublished books would be worth.
I cannot.
And they're part of Miss Lee's estate.
Yeah, that's lawyer talk, right? For stuff she owned.
That's right. They're part of what Miss Lee owned.
Yeah.
Whoever gets Miss Lee's stuff gets those unpublished works.
Yes, I believe books are stuff.
And if the defendant wins this case, she promised to give those unpublished works to you.
Yeah.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
Okay.
Now, Ms. Cabrera, opposing counsel just asked you a few questions about that August 14th meeting. Did Miss Lee ever tell you what she was meeting with her attorneys to discuss?
No, I mean, she's an important person, right? So I don't know.
Let's see. Now I want to move on to your conversation with Miss Mars. So if you do come into possession of Miss Lee's unpublished works, do you have any intention of selling those books?
No, because Agatha said she never wanted those to go public. So I mean, I'd read them for my own curiosity, but probably burn them after that.
So to be clear, do you have any intention of making money off of those books?
No, they'd go to the flames.
No further questions, Your Honor.
Any recross?
No recross, Your Honor.
May this witness be excused?
We're fine with that, Your Honor, if it's fine with the defense.
Okay. And then is the defense ready to call their second witness?
Yes, Your Honor. At this time, the defense calls Drew Mars.
Okay. And feel free to proceed when you're ready.
Yes, Your Honor. Can you please introduce yourself to the members of the jury?
Is Drew Mars.
Miss Mars, I think you cut out just for a second there. Could you say your name one more time for us?
Pardon me. Of course, my name is Drew Mars.
Miss Mars, why are you here today?
I'm here because Agatha Lee, a woman I worked for a decade, passed away. And her granddaughter, Stevie Rogers, is trying to frame me for killing her.
Objection, speculation, Your Honor.
Response?
Your Honor, the witness is only testifying to what she thinks is happening during this proceeding, and that perception is rashly based on the events that have transpired throughout trial that have already been testified to.
May I respond, Your Honor? This witness said definitively, Stevie Rogers is trying to frame me for killing Agatha Lee. Your Honor, that would require her to delve into the mindset and knowledge of Stevie Rogers, which she just can't do. If she wants to offer her opinion after she's laid foundation, she can do that, but to definitively say that with no foundation, it requires outside knowledge, which is inadmissible under Rule 602.
I'm going to overrule the objection. I feel like it's, in a way, it's sort of similar to what happened in the first half of the case. So I'm going to overrule that objection. And again, that's something you should feel free to probe into on cross-examination.
Yes, Your Honor.
Well, Ms. Mars, we've heard a lot today about what the plaintiff is accusing you of. I want to give you an opportunity to respond right away. Did you kill Agatha Lee?
Of course not. I loved Agatha. I never would have hurt her.
Can you tell us about your relationship with her?
Yeah. I was Miss Lee's caretaker since 2008. So she was my boss, but really she was so much more than that. She was my mentor, my friend. Honestly, she felt like a grandmother to me.
How do you know Stevie Rogers?
Stevie is Agatha's granddaughter. I met her back in 2008, but after that, she was away for a long time.
All right, Ms. Mars, just based on what you've observed, what was Agatha's relationship like with Miss Rogers?
Well, for the time that I was around, it was honestly non-existent. I remember there were nights Agatha would cry over the letters she sent Stevie that she never got a response to. But of course, I tried to help comfort her, to show her that she still had people in her life who loved and cared for her. People like me.
Well, you mentioned that you met Stevie in 2008. What was that first meeting like?
At first, I was so hopeful having Stevie home. I never saw Agatha smile brighter than when Stevie walked in the room, but I was skeptical too.
Why were you skeptical?
Because of a change in Agatha's will.
All right, Ms. Mars, I want to stop here and talk to you about those wills. What can you tell us about Agatha Lee's wills?
Well, Agatha's most recent will left her estate to me. That version was written in February of 2018.
What did being named the beneficiary of her estate mean to you?
When I first found out, I was shocked. I felt undeserving. Agatha had always paid me very generously. But to me, well, I had always felt so much love for Agatha. I hoped that maybe this was a sign she felt the same way.
Who would have received Agatha Lee's estate prior to 2018?
Prior to that, in her will, everything would have gone to Stevie.
How many months after Stevie was removed from Miss Lee's will did she come to visit?
Well, the will changed in February, and Stevie came to the house in July. So about 5 months.
To your knowledge, did Stevie know about this change?
I'm not sure if she was told, but Agatha still wrote letters regularly that Stevie never responded to, so it's possible.
All right, now, Ms. Mars, earlier you mentioned that you were skeptical upon her return, Stevie's return. What did you mean by that?
At first, I said that caused me to keep my
Ms. Mars, I think
more attention to what Stevie was saying and doing in the manner. Did I cut out again?
you cut out a little bit again. Could you start the answer from the beginning?
I'll repeat my answer. I said that at first it was something Agatha said that caused me to keep my guard up, to really pay attention to what Stevie was saying and doing in Lee Manor.
What did Agatha say that caused you to pay more attention?
She said she thought Stevie had just run out of money.
Objection hearsay to the statements of Agatha Lee.
Response.
Your Honor, we're not offering that statement for the truth of the matter, only for the subsequent action of Miss Mars. The fact that Stevie Rogers had run out of money upon returning to Agatha Lee's estate has already been established during her cross-examination.
May I respond, Your Honor? Your Honor, they don't need this statement to elicit Miss Mars' subsequent reaction. I have it on a good faith basis. They can just say what Miss Mars did. She can testify to that without needing this statement. They are using this statement for the truth value it has that Stevie had run out of money because, as they made clear in their opening statement and throughout today's trial, their entire motive for Stevie Rogers potentially committing this crime is that she ran out of money. They are using it for the truth, and they don't need it for the effect on the listener. So it is hearsay under 801.
I'm inclined to overrule the objection, in part because we did hear evidence to that effect, I believe, in the plaintiff's case in chief, at least certainly arguable that was the case. And I'm happy to issue a limiting instruction that it's not being offered for the truth from this witness, but rather to explain subsequent actions that were observed. So the objection's overruled.
Yes, Your Honor.
Miss Mars, what did you do after Agatha told you about Stevie's money?
Well, after Agatha told me that, I made sure to pay attention to what Stevie said. Anything she said about money, I didn't want Agatha to get hurt. And it turns out I was right to be cautious because soon after, Stevie said something that confirmed my concerns.
What did Stevie say?
Well, she asked Agatha about the will.
When did Stevie Rogers ask Agatha about the will?
It was on August 14th, the day that Agatha died.
All right, Miss Lee, I want to pause here and talk to you about that conversation. Can you tell us about how it started?
Of course. I was bringing Agatha her tea in the study, just like I do every morning. But I heard voices inside, Stevie and Agatha, so I stopped at the door. I didn't want to interrupt. I caught a couple words, though, about the will.
What did you hear?
Well, Stevie said, "I know you cut me out of the will, but I really hope you'll reconsider."
Did Agatha respond?
Well, she refused, and Stevie walked out a moment later, stomping and huffing. But it was what Stevie said to me after that that really concerned me.
What did Stevie say after Agatha refused?
Well, she sort of stopped me in the other room. She was glaring at me and she told me, "Don't count your millions yet."
Ms. Mars, what happened after that conversation?
I took Agatha to lunch, ran a few errands.
How long were you gone from Lee Manor that day?
About 2 hours, between noon and 2 p.m.
To your knowledge, was anybody at the house when you left?
Only Stevie was there when we left. I'm not sure if she stayed in the manor the whole time or went out somewhere, but she was the only other person I saw in the manor all day.
While you were gone, do you know what Stevie was doing?
No, I have no idea.
Miss Mars, were any of the doors in the house locked when you left?
Inside? Not to my knowledge. I didn't lock any of them.
Did you lock your door?
No, I never locked the door to my room.
Miss Mars, what happened after you returned home at 2 p.m.?
And dinner a little later, brought it to Stevie and Agatha in the study.
Sorry, Miss Mars, I think you cut out one more time. I'll re-ask the question. What happened after that conversation? What happened after you returned home?
Agatha took a nap, and a little later I brought dinner to Stevie and Agatha in the study.
When was the next time you saw Agatha Lee?
After dinner, I just went up to bed, so the next time I saw her was at 8:30 a.m. the next day when I found her dead in her bed.
Do you know how she died?
Yes, I found out later after her toxicology report. She died from an allergic reaction to chloroandramine.
What is that?
I learned about it in nursing school. It's a drug for heartburn.
Are there any drugs that look similar in appearance to chloroandramine?
Yes. Unfortunately, it looks almost exactly like Winterin, a drug that Agatha takes every day.
Did anybody else know, rather, about Agatha's allergy?
Yes. Earlier that week, Stevie asked me about Agatha's medication, and I told her about the allergy.
Thank you, Ms. Marsh. No further questions at this time, Your Honor.
Cross-examination.
Yes, Your Honor.
Anytime you're ready.
Ms. Mars, I want to ask a couple of questions about you, but before I do that, I want to address something you said on direct. You said that you believe Stevie Rogers is framing you for Agatha Lee's death, right?
Yes, that's why she's suing me in court today.
So let's make this clear for the jury. The night before Agatha died, you never saw Stevie go into her room.
No, like I said, I went to bed early that night.
The night before Agatha died, you never saw Stevie holding any pills, right?
No.
The night before Agatha died, you never saw Stevie tampering with Agatha Lee's pill organizer. Isn't that correct?
No, I never saw her do that.
All right, Ms. Mars, I want to actually move on and talk about Agatha Lee's will. In February of 2018, you realized, just like you said a couple minutes ago, you were being put in her will.
Yes, and in February, she changed her will to make me the beneficiary. I knew that.
And not only were you the beneficiary, when she died, you would get everything she owned, right?
That's true.
And there was actually a will reading on August 20th after Agatha had passed away. Isn't that right?
That's right.
And when the will was read, the person reading it said, all of my estate, all of Agatha's estate would go to you, right?
Yes, it was one of the most shocking moments of my life.
And when the lawyer read that will saying all the money would go to you, you acted surprised.
I did. I was awestruck. I never expected to have this much money in my life.
You acted surprised even though you already knew you were going to get all of that money from the will, right?
I did.
You even admit that you acting surprised, oh, that was a lie.
Well, I did already know I was getting the money. Like I said, I was just so shocked.
So that's a yes to my question, Ms. Mars. That's a lie, in your own words.
Yes.
And the reason you lied is because you didn't want the police to think you had motive to kill Agatha Lee.
Well, I didn't want to make the attention on me, that's true.
So directing you back to my question, you didn't want the police to think you had motive to kill Agatha Lee, yes or no?
Of course not. I never wanted to hurt Agatha.
Not only did you not want to hurt her, you didn't want the police to think you had motive to do it, right?
Of course not.
So let's move on to the terms of that will. Now, Miss Mars, you admit your family, you've never been particularly wealthy, right?
No, that's true.
A lot of the money you made as Agatha's caretaker, well, you sent it back to your family.
Yes, Agatha was very generous to me, so I was lucky enough to have extra to send to my family.
You'd agree your family, well, they needed that money.
Sure, yeah, any help.
And Ms. Mars, one of the reasons your family needed that money is because your sister was sick and had medical expenses, right?
That's true. My sister's been battling cancer since we were young children. It does get expensive.
But when you found out that you were going to be in Agatha's will, you realized you might never have to worry about money again, right?
Well, yes, it's a lot of money, more than I've ever imagined having.
You know that Agatha's cash alone, well, that was worth upwards of $20 million. Isn't that right?
That sounds about right.
If you got that $20 million, you'd be able to pay for all of your sister's medical expenses with no problem.
That's true.
But you'd only get the money from the will if Agatha passed away.
Well, sure, of course.
And if your sister passed away before Agatha did, you knew you wouldn't be able to help her.
Well, that's true, but luckily my sister's still fighting. She's
So
alive.
that's a yes, Miss Mars. If Agatha died after your sister, you wouldn't be able to help your sister.
Well, no, that's not true. I still help my sister with my salary.
Well, Miss Mars, you'd agree with me that if Agatha died after your sister, you wouldn't be able to use the money from that will to help her, yes or no?
Right, not the money from my will, from her will, just the money that I earn.
For you to help your sister, Agatha would need to die before her.
No, that's not true. I help my sister to this day.
Is there your testimony that you'd be able to help your sister if she died before Agatha?
I could use the money that I earn, but obviously not the money from the will.
You remember writing a deposition or being deposed for this case, right, Miss Mars?
Yes,
And do you have your deposition in front of you?
I do.
And in this deposition, you were required to tell the truth, isn't that right?
Yes, I answered everything truthfully.
And you agreed to include any relevant information for this case about the death of Agatha Lee, isn't that right?
I did.
And Miss Mars, if you could turn to line 146 for me, should be on page 5.
Yes, I see it.
And if you could read aloud, or read silently while I read aloud. Question, what do you mean? Answer, Agatha was in good health. I knew my sibling might die before Agatha passed, and I wouldn't be able to help my sibling. I read that correctly, didn't I, Miss Mars?
Exactly. I wouldn't be able to help her with the money from the will.
Oh, hold on, Ms. Mars. You didn't say with the money from the will in that statement in your deposition. All you said is you wouldn't be able to help your sibling. Yes or no? Those are the words you
That's
said.
right. You read it correctly.
All right, Ms. Mars. Now I want to move on to how Agatha Lee died. You know she died because she was poisoned with 2 pills of a drug called chloroandramine.
That's what I found out from the toxicology report, yes.
And you knew she had been allergic to that drug ever since you started working with her.
Yes, her previous caretaker told me that that's actually the drug that caused a heart attack.
And you know that that drug, chloroandramine, was virtually identical to her arthritis medication.
Yes, that's true.
Ms. Mars, you're the one who puts Agatha Lee's arthritis medication in that pill organizer.
Exactly. Every week I set up the pill organizer on Saturday with all of her pills for the week. I don't really touch them after that.
And every day she takes the pills that you put in there.
Right. Like I said, I set them up at the beginning of the week and then she takes them every day.
I want to talk about how you could have gotten your hands on chloroandramine. It's an over-the-counter drug, right?
Yes, it is, but I never bought any chloroandramine.
You can get it at a pharmacy.
Sure, anyone can get it at a pharmacy.
On August 14th, the day before Agatha died, you went to a pharmacy, right?
Yes, I was running errands that day for Agatha and I.
And Miss Lee, when the police, they searched your closet, they found a black bag with pills of chloroandramine in it, right?
Yes, they found a bag in there and I have no idea how it got in there.
Well, Miss Lee, the bag containing the substance that killed Agatha Lee, it had your fingerprint on it, yes or no?
The bag had my fingerprints on it because I was rummaging through my closet earlier. I have no idea how that bag got in there, and I certainly never bought those pills.
Well, I know you're saying that now, Miss Mars, but I'm just directing you back to my question. The bag containing the substance that killed Agatha Lee had your fingerprint on it, yes or no?
Yes, but I never bought those pills.
Thank you, Miss Mars. Nothing further.
Is there a redirect?
Yes, Your Honor.
Go ahead.
Miss Mars, what was your salary while you were working with Agatha Lee?
Miss Lee paid me $80,000 a year, and most of that went to my family, including my sibling.
Did you ever have to ask for a raise?
No, never. Agatha gave me a raise every year without even asking.
Did you ever ask for a raise?
No, of course not. I always felt that I was paid very generously. I never felt the need for more money.
If you needed the money, what would you have done?
Well, if I needed the money,
I misspoke. What did you do with the money you actually received?
well, most of it, like I said, I gave to my family. I had no living expenses since I lived at the manor, and Agatha bought all the food for the house, so I didn't really have to spend much on myself.
Thank you, Miss Marsh. Nothing further, Your Honor.
Any recross on that limited basis?
Your Honor, I only have 5 seconds left, so no recross.
Okay. All right. Thank you very much. And does the defense rest at this point?
Yes, Your Honor.
Okay. There's no provisions for taking a break. It doesn't specify one way or the other. Would counsel like to take, for closing arguments, would they like to take maybe, I don't know, maybe 3 to 5 minutes for preparation? Or, I don't know, assuming we can, bailiff?
If we have time, Your Honor, 5 minutes would be great for the plaintiff.
All losses in about 25 minutes. I think that we should be able to take a 3 to 5 minute break with that.
Okay.
In mind.
So I show that it's 1:43 p.m. Why don't we come back no later than 1:48 p.m.?
Yes, Your Honor.
Yes, Your Honor.
And again, just remember that this is being live streamed, so everyone, please act accordingly.
For our judges, I see Ian's messaged me that he's back. If the rest of you can just let me know that you're here. Perfect. Awesome. Got you, Nick. I believe we're good to go. Oh,
Perfect.
Gautam, I believe.
Yep. Got it. Thanks. Is the plaintiff ready to make their closing argument?
Yes, Your Honor.
And defense, you're also ready?
Yes, Your Honor.
Okay, perfect. Plaintiff, whenever you are ready.
May it please the court to stay in the will she had to kill. Members of the jury, February 1st of 2018 was the best day of the defendant's life. That was the day her elderly patient, Miss Agatha Lee, decided to name her the sole heir to a $25 million estate. All the defendant had to do was sit and wait, and she would be set for life. But we heard today all that changed when Miss Lee's only living family member, her granddaughter, Stevie Rogers, showed up at her house. And then we heard about August 14th. We heard that the defendant, with her ear pressed against Miss Lee's study door, overheard a conversation in which Miss Lee promised to change her will and give that entire $25 million fortune to her granddaughter, meaning the defendant would get nothing. The defendant didn't know when this change would happen. All she knew was that it would be soon. With the window of opportunity to get that $25 million closing fast, she had to get creative. To stay in the will she had to kill. Miss Rogers saw the defendant that night enter Miss Lee's bedroom armed with intimate knowledge of her medical history. In minutes, the defendant switched 2 pills of Miss Lee's arthritis medication with 2 pills of deadly chloroandrami. All the defendant had to do was sit and wait for Miss Lee to go to bed, to take her pills like she always did, and then die in her sleep. No one would be wiser that this was anything more than an elderly lady dying in her sleep. And the defendant would walk away $25 million richer. To stay in the will she had to kill. But unfortunately for the defendant, killing someone to profit off their death is illegal. In Midlands, there's a law called the Slayer Statute that Mr. Gonda mentioned in opening. And what this law states is that if you kill someone, you can't receive any part of their estate. We as the plaintiff had the burden to prove to you today that Miss Mars, the defendant, knowingly or purposefully caused the death of Miss Lee. And we did, by showing you how she killed Miss Lee. So let's start with that. Let's start with how. Now we have this autopsy that shows that Miss Lee died from ingesting 2 pills of deadly chloroandrami. Members of the jury, it's lucky we even have this much information, because if the defendant would have had her way, we would have never known. Mr. Bond told us that when the police arrived, the defendant insisted Miss Lee's body be cremated as soon as possible. If the defendant had her way, if Miss Lee's body was cremated, there would have been no autopsy. There would have been no toxicology report. There would have been no evidence of chloroandrami poisoning. All that evidence would have gone up with smoke. And there's a reason that the defendant didn't want us to know that Miss Lee died from chloroandrami poisoning, because the defendant had to admit she was one of the only people that knew that Miss Lee was deathly allergic to chloroandrami. She had to admit she had access to Miss Lee's medications and to her pill organizer. And we also heard that she was giving Miss Lee an arthritis medication pill that looked identical to chloroangemine, looked identical, tasted identical, smelled identical. It was impossible for Miss Lee to tell the difference. Now, the defendant was the only one with that knowledge, the only one who knew how easy it would be to switch those two pills. And we know that's what the defendant did because Mr. Bond told us that 2 of her fingerprints were found on the arthritis medication in that bottle. That was the only place in Miss Lee's medication that the defendant's fingerprints were found. And that's because the defendant took those 2 pills of arthritis medication, put them back in the bottle, and replaced them with 2 pills of deadly chloroangemine. So the defendant had the knowledge. She knew that Miss Lee was deathly allergic to chloroangemine and knew how to get it. She had the opportunity. She had access to Miss Lee's medication, to that pill organizer. But there was more than that because that arthritis medication wasn't the only place the defendant's fingerprints were found. We heard from Mr. Bond that the police found a bag filled with chloroangemine in the defendant's closet, with the defendant's fingerprints and only the defendant's fingerprints. Now, the defendant, she got up here and she tried to deny that this was her bag, that she'd ever touched it. But members of the jury, I want you to pay close attention to where that fingerprint was found. On the zipper, on the place where you open that bag. The defendant had the knowledge, the opportunity, and the murder weapon. So that takes us to why. Why would the defendant want Miss Lee dead? We know she overheard a conversation the day Miss Lee was poisoned between Miss Lee and her granddaughter about Miss Lee's estate. Now, Miss Rogers told us about that conversation, that Miss Lee promised that $25 million estate to her granddaughter, not the defendant. The defendant, she tried to deny the contents of that conversation. But I want you to pay close attention to what she had to admit happened afterwards. Because the key is in the context, members of the jury. Immediately after that conversation, Miss Lee got on the phone, called her attorneys, and scheduled an appointment for that Friday. You heard from Miss Cabrera that she was meeting with her attorneys that Friday. Members of the jury, it's clear she was meeting with her attorneys to change that will. It happened right afterwards. You know what the defendant was doing during this time? The defendant went to a pharmacy with a wad of cash. It's clear she went to that pharmacy to buy chloroangemine after hearing this conversation, because at that point she knew to stay in the will she had to kill. Most reasonable people like me and you might not think $25 million is a good enough reason to kill someone who trusts you. But we know the defendant felt differently, because I want you to think back to that will reading. When Miss Lee's attorneys announced that the defendant was going to get all this money, said, I don't know. I had no idea. I can't believe it. Members of the jury, she lied. And on cross-examination, she had to admit that she lied. And we know that she lied, that she knew she had to admit she lied, because there was an email found from February 2018 where the defendant admitted she knew that she would get all this money if Miss Lee died, as long as she stayed in the will. And to stay in the will, she had to kill. Do not let the defendant profit off of Miss Lee's death. Find for the plaintiff. Thank you.
Thank you, Ms. Burdett. Is defense ready to make their closing argument?
Defense is ready, Your Honor.
Whenever you're ready.
To adjust. Moment of court's indulgence.
Sure. Take your time.
May I proceed?
Yes.
May it please the court. Stevie Rogers framed Miss Mars to steal the fortune. Mr. Alexander, if you could pull up Exhibit 5. Exhibit 4, apologies. Now, members of the jury, I want you to remember that at the center of this case is this estate right here. Plaintiff counsel and I agree that this case is not a personal stake against Miss Lee. No, it is about this estate. This beautiful house, almost $20 million in cash, and another $3 million in book royalties on top of all that. Stevie Rogers framed Miss Mars to steal this fortune. Now, at the beginning of today's proceedings, my co-counsel, Mr. Alexander, got before you, and he explained the burden that the plaintiff bears in today's case. Because let's be clear, the plaintiff and only the plaintiff bears a burden today. Now, in a moment, you're going to go back and deliberate on this case. And you're going to be given a set of jury instructions that are going to help you to decide how to render your verdict. And I want you to pay attention to that burden of proof, because it means that if you do not believe, it is more likely than not that Miss Mars knowingly or intentionally ended Miss Lee's life, then you must rule in the defense's favor, and you must let Miss Mars access the inheritance that she deserves. Now, opposing counsel just got up here and she talked to you about a desperate plot by Miss Mars, how said that she, in order to stay in the will, she had to kill. But members of the jury, I want you to think about whether that makes any sense. Mr. Alexander, please pull up Exhibit 10. When Agatha Lee cuts someone out of her will, we know how it happens because she already did it to Miss Rogers in February, and she makes it clear. We've become family in name only. Members of the jury, are we really to believe that Miss Lee was kind enough to put Miss Rogers back in the will after just a month after meeting with her, but was cruel enough to cut Miss Mars out of the will without warning her, without an email, without a single letter, without talking to her in the car that day? Members of the jury, that does not make sense. What makes sense here is the truth. As Miss Mars told you, and as Miss Cabrera corroborates, Stevie Rogers asks for something that day. That something was the inheritance. And Miss Lee said no, just as she did in February. Mr. Alexander, you can take down the display. But maybe you're thinking, well, even if she wasn't about to be written out of the will, maybe that was still the motive, to get the inheritance faster. But members of the jury, Miss Mars was making $80,000 a year plus room and board as a nurse already, with more coming every year. Are we really to believe that she would take that salary away? She would risk losing the entire inheritance, that she would risk getting a murder conviction, not even to secure the inheritance, but just to get it a little faster? Well, that doesn't make sense either. What makes sense here is the truth. Is that Miss Mars, no matter how you cut it, doesn't have a motive. But there was someone at that manor who did have a motive. Mr. Alexander, if you could please pull up the Slayer statute. In June of 2018, Miss Rogers' trust fund ran out. In August of 2018, she asked for her inheritance to come back to her, and Miss Lee said no. So Miss Rogers had a plan, because there was another way to get that inheritance. If a court believed, by a preponderance of the evidence, that Miss Mars ended Agatha Lee's life, then Miss Mars would get nothing. And Miss Rogers, well, she would get everything. The house, the money, the royalties. All she had to do was meet that preponderance of the evidence. You can take down the display. She had the motive. She could get the means. There are 15 drugstores in Ryder County with chloroanandramine on their shelves, a drug which she knew Miss Lee was deathly allergic to. Now, Mr. Bond talked about means and motive. You might have noticed that there's a part of that framework that he left out, and that's opportunity. Because I want you to remember that between noon and 1:30 p.m. on August 14th, not a single other witness in this case could corroborate where Miss Rogers was. Both Miss Mars and Miss Lee or outside of the house. 90 minutes of time is more than enough time to drive to a drugstore and buy chlorandramine. 90 minutes is more than enough time to go into Agatha Lee's bedroom and find her pill organizer. And 90 minutes is more than enough time to switch those pills out. And from there, all she had to do was wait. Now opposing counsel just talked to you a lot about forensic evidence, but I want you to think how much of it really makes sense. Now, she just talked about 2 fingerprints on those Winterin pills in Miss Lee's house. Now, I have a pill bottle right here. And I want you to remember that Miss Mars was responsible for administering Miss Lee's pills every week. She took them out of the pill bottle and she put them in the pill organizer. And opposing counsel is trying to say that the fact that she touched these pills is evidence. And that does not make sense. She also talked to you about the fingerprints on that bag, but let's be clear here. The chlorandramine in there was in a bottle, and there was not a single fingerprint belonging to the defendant on that bottle. Now, Mr. Bond took the stand and he talked to you at length about those pills. And I want you to think about why they even called Mr. Bond in the first place, because you'll notice Detective Khan isn't here. That was the lead investigator on this case. Dr. Quincy, the medical examiner who performed the autopsy, isn't here. Dr. Ryan Reeves, who performed the tox screen, isn't. No, the one investigator they called is the one person the plaintiff is paying to be here. And why would they do that, members of the jury? Well, it's not because he did the most thorough investigation. This was a case with a financial motive, and he didn't ask if either person at the house had a financial motive. It's not because he followed standard procedure. He told you on cross-examination that he did not work with law enforcement. When he got that email evidence, he didn't show it to Detective Khan. He didn't help the investigation, which at that point was a murder investigation. No, he sat on that evidence. So I need you to ask, why would he do that? Why would he withhold that evidence? Well, the answer to that is the same reason why Miss Rogers called for a tox screen and an autopsy before she had any reason to believe that Miss Lee's death was foul play. It's the same reason why that chlorandramine was found in the defendant's closet. It's because Miss Rogers knew exactly what they were going to find. Miss Rogers was not looking for a true investigation. No, when she hired Mr. Bond, she was looking for a mouthpiece. Someone to be loud and to show off the evidence that she planted in this case, because she framed Miss Mars to steal the fortune. Members of the jury, when you go back to deliberate on this case, I want you to consider all the evidence. And I want you to remember that you do not need to assign weight to evidence that is obvious nonsense. You don't need to assign weight to testimony and evidence that is a clear lie. And you don't need to assign any weight to evidence that is a result of a framed job. Members of the jury, I ask that you give the one verdict that is consistent with the facts. Let Miss Mars walk out of this courtroom as innocent as she was when she walked in. Find her not liable. Thank you.
Thank you, Mr. Young. And then, I don't know, is there a plaintiff rebuttal? I don't have any notes on that.
We have about 20 seconds before we hit all, to run it before we hit all law, so.
Okay, so we'll scrap the rebuttal then. And then I guess judges, if we could, scoring judges, if we could go ahead and fill out ballots and submit them as quickly as